What's your badge number, by the way?
It's season 3 of Riding with the Outlaw.
Mr. Chain, so in light of the county prosecutor's office being informed multiple times of the other party wanting to drop the charge, and in light of the county having no evidence, in fact, exculpatory evidence, of my innocence, it still chooses to pursue the charge of harassing phone calls. Well, that just about validates everything that I've said and lays claim to my claims of prosecutorial misconduct, malicious prosecution, and preferential prosecution, while validating the claims of this being a guilt-stricken witch hunt involving the county trying to use fear and intimidation tactics to cover its tracks. I personally am of the opinion that this move places the county in further violation of 42 U.S. Code 1985 in its tactics to further deprive the rights of the defendant by intentional interference into ongoing civil rights litigation, and shows a willful malice intent. The county and state is bringing these actions with the most unclean of hands, and I intend to prove it had knowledge of such, and its persistence further exacerbated injuries sustained. The DUI was staged by the county. Not only was no marijuana found, but I was never searched, nor was my car truly searched, and I have an eyewitness to that. I'm not a law enforcement officer, yet I know that if questioned on the procedure and protocol, 9 out of 10 law enforcement officers would likely note that this was out of protocol. There was, however, an insistence on non-permissive transport under false arrest due to being handcuffed and taken to the jail to take a field sobriety test which fell outside of Terry stop time stipulations. Not to mention anyone watching would see that no impairment existed, and that the county actually chose to fault me for the struggle in supporting weight on a bad knee injured from a motorcycle wreck, which was shown and communicated up front on camera. No follow-up testing or confirmation was done to detect the presence of any substance. All of this but certainly makes this charge fall apart. The improper equipment was never notated and specified, which means the ticket in essence was written open-ended, giving the officer the ability to change his or her story up until the day of trial. If the charge is in regards to a headlight being out, well, it went out that evening due to the ice storm and icing. What type of money racket is Lafayette County running here to further financially penalize me for an act of God and nature, especially when this county is 100% responsible for disenfranchising me and my family to the fullest from its 2017 stunt? So that one most likely is gone. And finally, there's the disorderly and resisting arrest charge, where I parked next to the sheriff seeking out equal protections of the laws, which quite frankly were downright refused and neglected. I only went up there to seek out the sheriff of the county due to his checking my emails of grievances relayed regarding criminal behavior, which had been allowed to continue unchecked at the infliction of intentional damages on me. It was after normal business hours, and the signs indicated for sheriff's department, not for sheriff's deputies.
I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department. I'm here at the sheriff's department.
You will go to jail for disorder.
I'm not being disordered.
Of course, I recorded everything until I was cuffed, and I was able to switch off the recorder in order to ensure the evidence was obtained. The audio recording shows both officers Dixon and Howell lied on their written statements, which would demonstrate a conspiracy of 2 or more officers acting under color of law, conspiring to deprive another of their civil rights. Look up 42 U.S. Code 1985 and 42 U.S. Code 1983, and that just about 100% describes what all has happened here. Because I never once said no, despite Courtney Dixon quoting that I said it 3 times.
Hey, you gotta move that.
I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department. I'm here at the department.
Or you will go to jail for disorder.
I'm not being
Remember this
disorderly.
phrase.
I'm moving my car. I'm moving my car.
When freedom is outlawed,
moving my car.
only the outlaws will be free.
I was moving my car.
I don't mind being an outlaw at all.
Stop.
I don't mind wearing it on my shirt. Now I've got to get in here and see what I can figure out on requesting even more public records. They didn't comply with the first ones or with these last ones. So now I'm going to go request more. And let's see if they continue to obstruct. I think the Lafayette County Sheriff's Department probably needs to receive a few phone calls. In fact, I'd love to hear that phone line go crazy while I'm inside right now. I think the number is 662-234-6421. Let them know what you think about that. Take care.
Hey, you gotta move that. I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department.
One more time.
I'm here at the sheriff's department.
Move. Or you will go to jail for disorder.
I'm not being disordered. I'm moving my car. I'm moving my car. I was moving my car. Really? I thought I was moving my car. Oh, stop.
We're about to make the argument of the stacking them. Also, if it's up to the judge's discretion to either give you or not give you a jury trial, what are your reasons why in these cases you need a jury trial? You can't get a fair trial from people.
Because I think that it's very easy to see with the video evidence. I had an audio recorder in my pocket December 28th on the disorderly and resisting arrest charge. Courtney Dixon came out. He didn't actually ask the things that he actually put in his written statement. And then him and the other guy, the other officer, they both said in quotations that I said no, that I would not move my vehicle 3 separate times. Now, my audio recorder shows me never saying no one time. I'd be completely horrified.
So why can't he decide that? Why is the jury needed to decide that as opposed to he deciding?
Well, I think that in light of I've had extreme prejudicial treatment since 2017. It was something that I've raised evidence of prosecutorial misconduct. It was a setup by the county. There are multiple defendants in this, including the sheriff, Joe East. It is not fair for me to go to trial where one person decides my fate when I'm demanding 6 people decide my fate, 5 out of the 6 or more, because this thing has been so heavily tainted since day one. I'm doing a documentary. This town, this area just freaking hates me. They've gone to every extent to get rid of me, to abscond with their guilt. They made me sign a covenant to not sue Lafayette County, the Sheriff's Department, the City of Oxford, its elected officials, and basically the mayor.
All right. We shall make those arguments.
42 U.S. Code 1985. Paragraph 2. Obstructing justice, intimidating party, witness, or juror. If 2 or more persons in any state or territory conspire to deter by force, intimidation, or threat any party or witness in any court of the United States from attending such court, or from testifying to any matter pending therein, freely, fully, and truthfully, or to injure such party or witness in his person or property on account of his having so attended or testified, or to influence the verdict, presentment, or indictment.
I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department. I'm here at the sheriff's department.
Or if two or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory, with intent to deny to any citizen the equal protection of the laws, or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to the equal protection to the laws.
Or you will go to jail for disorder.
I'm not being disordered. I'm moving my car. I'm moving my car. I was moving my car. I said I was moving my car. Oh, stop.
Paragraph 3. Depriving persons of rights or privileges. If two or more persons in any state or territory conspire to go in disguise on the highway or on the premises of another for the purpose of depriving, either directly or indirectly, any person or class of persons of the equal protections of the laws, or of equal privileges and immunities under the laws, or for the purpose of preventing or hindering the constituted authorities of any state or territory from giving or securing to all persons within each such state or territory the equal protection of the laws, or if two or more persons conspire to prevent, by force, intimidation, or threat, any citizen who is lawfully entitled to vote from giving his support or advocacy in a legal manner toward or in favor of the election of any lawfully qualified person as an elector for president or vice president, or as a member of Congress for the United States, or to injure any citizen in person or property on account of such support or advocacy in any case of conspiracy set forth in this section, if one or more persons engaged therein do or cause to be done any act in furtherance of the object of conspiracy, whereby another is injured in his person or property, or deprived of having and exercising any right or privilege as a citizen of the United States, the party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. The foregoing petition is in regards to the current ongoing criminal charge of disorderly conduct and resisting arrest, which are identified in this court under cause numbers 9290609 and 9290610, respectively. The plaintiff in this particular matter brought forth is Matthew Reardon, whom hereby petitions for a writ of mandamus and seeks relief from the trial court, trial judge, and ruling made on March 1st, 2021. Plaintiff states that the defendant judge, Mickey Avon, acted outside of his jurisdiction, of his office, and even authority in this particular situation in ordering that the plaintiff cease recording of proceedings brought forth in this court. The trial judge did so, citing Rule 1.03. The trial judge referenced the Uniform Rules of Procedure for Justice Court. Plaintiff stated on numerous occasions that he felt he couldn't get a fair hearing in the Lafayette County Justice Court due to events that have taken place over the past 3.5 years, all stemming from the crippling decisions made in this very court when Judge Carolyn Bell took it on herself to set plaintiff's bond at $150,000 on a felony charge levied against the plaintiff in May of 2017, which not only lacked probable cause, but deprived the plaintiff of his due process rights along with his civil liberties by setting bond in a punitive way, even when plaintiff asserted he had solid proof that he couldn't have possibly committed such crime. Plaintiff had assertively claimed reservations and worries that he had, including recently demonstrating how he feels that he's demonstrated Lafayette County officials and agencies denying the plaintiff of equal protections of the law
which are granted not only by Article 3 of the Mississippi Constitution and its Bill of Rights, but the federal Constitution, which plaintiff swore a lifelong oath to protect and defend. Plaintiff would vehemently affirm before this court that he has remained on the receiving end of repetitive targeting by way of preferential prosecution, which over and over has exceeded the threshold of malicious prosecution and even prosecutorial misconduct. Not only is this blatant to the plaintiff in this cause, but it should be blatantly clear to any onlooker, not only with this cause, but the other open causes filed in this court as well. When all evidence is assessed in November 2020, plaintiff was involved in a case in Olive Branch, where he was charged with contempt, despite doing exactly what he was asked to do by the court. Fortunately, the case was just dismissed on March 1st, 2021 due to plaintiff carrying a tape recorder which corroborated exactly that which the plaintiff claimed. The alleged false arrest is currently on file and pending before the U.S. District Court of Northern Mississippi, referenced by case number 320-CV-00327-DMB-JMV. It is reasons like this that the plaintiff feels it is a paramount need and one that each court should allow. In fact, plaintiff is of the impression that this is a request that should be looked at as an accommodation, and one that's no different than any accommodation afforded to Americans with disabilities under the Americans with Disabilities Act. The trial judge read off the title to 1.03 in the Uniform Rules of Procedure for Justice Court. However, after the title, nothing made sense to the plaintiff, and it almost felt to the plaintiff that this reading was being falsely read and presented to the plaintiff. However, Rule 1.03 states as follows. Use of cameras. The use of cameras, recording, or broadcasting equipment, or such shall be governed by the Code of Judicial Conduct. Plaintiff would state that not only does 1.03 lack any language that would bar the use of an audio recorder, especially in lack of a court reporter/transcriber. This in turn poses prejudicial and completely one-sided to the plaintiff, where everything is left up to hearsay in the absence of proof. Plaintiff requested to motion the court for him to be allowed to audio record the hearing and was immediately denied, further being told something to the effect of, "The rules are the rules." Plaintiff hereby quotes Rule 2.03, additional rules out of the Uniform Rules of Procedure for Justice Court, which states as follows. No rule of procedure, local or otherwise, shall be adopted without the approval of the Mississippi Supreme Court. Plaintiff would request answer from this trial court, and specifically the trial judge, as to if he and this court had approval of the Mississippi Supreme Court to establish such a rule that adversely can affect the outcome of a legal proceeding, and one which is clearly not spelled out in the reference rules of Uniform Rules of Procedure for Justice Court. The plaintiff would then jump down to Rule 3.01, applicability of rules, in the same referenced outline. Rule 3.01, Rules of Criminal Procedure in Justice Court are governed by the Mississippi Rules of Criminal Procedure. General rules are also applicable in criminal cases. When taking a look at the Mississippi Rules of Criminal Procedure, which just so happens to be the true governing doctrine, and examining the facts of this case, it would appear that the rights of the plaintiff on this motion have been affected in a way that could create a material breach of even more entitled rights of the plaintiff. Rule 1.10 of the Mississippi Rules of Criminal Procedure details recordation of proceedings where official court reporters are not provided. Any attorney of record or pro se litigant in a court which does not provide an official court reporter may record or have recorded any court proceeding by audio recording device or stenography. Any expenses incident thereto shall be borne by the party or parties. Plaintiff has attempted to raise multiple instances of irregularities and what would easily appear to be unscrupulous, immoral, and unlawful conduct demonstrated by deputies on site while arrest was made. Plaintiff will not concede his notion that this arrest was a targeted, unwarranted, and further unlawful arrest made with excessive force used, and all for the plaintiff commuting to the sheriff's department to communicate his grievances with Sheriff Joey East. Plaintiff has been denied access to the closest camera angle of arrest,
which plaintiff wholeheartedly believes is an attempt to hide or cover up wrongdoings in following plaintiff's assertions of not being afforded equal protections of the laws. As such, it is for these reasons listed that the plaintiff believes the idea of a fair and impartial trial is at an improbability and nearing an impossibility to the plaintiff. As such, duress is taken over. The plaintiff respectfully request answer from this trial court and the trial judge, along with a review of such from the Supreme Court of Mississippi. As plaintiff feels as though not having a court reporter, no jury, and no recording equipment potentially paves way to a constitutional crisis and has a habit of removing all fairness from a proceeding that should be comprised of fairness. Plaintiff also requests answers to why Lafayette County is refusing to produce the closest camera angle of the arrest and parked vehicle despite resistance on the matter. Plaintiff feels that this information is not privileged and is nothing more than the Lafayette County Sheriff's Department and Lafayette County officials yet again attempting to cover their tracks. Plaintiff hereby requests that any and all hearings in this court involving him be pushed back to allow proper response and adherence to request. If this court, the prosecutor, and the state of Mississippi wishes to proceed on with this cause and not dismiss in light of the information brought forth, then plaintiff hereby invokes his right to a trial by jury of his peers, as guaranteed to him by the state and federal constitutions. Respectfully submitted this 2nd day of March 2021, Matt Reardon, the Oxford Outlaw.
Joey East, how you doing, sir? I needed to get a little Q&A with you.
I don't do Q&As.
You don't do Q&As?
No.
Oh, can you answer a few questions for me?
No, I can't.
Y'all want to hear about one of the nastiest public corruption scandals? Agencies that are obstructing justice, destroying evidence, and turning a blind eye. Why is the county not wanting to comply on the public records request? You told me...
You probably have to ask the county, man.
You told me that if I submitted it, y'all would comply. That was the last time that we spoke.
I told you we'd look at it.
Shoveling. Proof of innocence. You said that we will comply. You said submit it and we'll comply. Why haven't I gotten...
Hey, Matthew.
Why haven't I gotten... And shielding criminal activity. Really, Sheriff, is this really the position you're going to take? That it helped get a female
why won't you even answer
Democrat
that?
elected. Look, hey, y'all will not respond to anything. Any email, any public records request, anything. I want to know why. I am holding our county officials accountable for this. You know I was framed.
Robin Tannehill was sworn in on June 29th. She ran unopposed, and Tannehill says that allowed her to hit the ground running.
Over the past couple of years, I realized there were a whole lot of things I wanted to change, that I had to be in this seat.
That was one of your ringleaders right there. The attorney of my ex for the original child custody matter back in 2016, August of 2016. It was that time that my child was kept from me for approximately 2 months.
She says it's her community involvement that helped her prepare for the role she's in now.
You know, that doesn't really prove anything, but other than us as a community, we do need to get together and try to figure out our problem resolution here, because Matt Reardon is a danger to our society, and he's going to be a problem, mark my words.
Who are you trying to protect? Is it that there's no call that came in, or is it that there's somebody like Robin Tannehill or Ray Tannehill that's on that call? I want to know. Why are y'all cowards? Why are y'all cowards? I'm saying I would like to, I'm trying to ask you.
I said no to an interview.
You said no to?
Now back away from my truck.
You do realize you're a public servant, right? Jared Bundren. Hey, I'm here to show you how to conduct a proper investigation. I would like to, do you have a minute?
No, I don't.
You don't? You received a call on May 24th, 2017. I would like the details of that call. Jared, I put in a public records request. Why are y'all not complying with the public records request? It's ridiculous, guys. It's absolutely ridiculous. Absolutely ridiculous. You got the May 1st, 2017 arrest in front of that statue right there, where I was holding the state flag of Mississippi, standing on public property, not bothering a soul, just standing on this very pavement that I'm standing right now, holding the state flag of Mississippi. May 1st, Deputy Sheriff Timmy Pruitt pulled up. He asked me if I had a permit to be here. I told him that I had the First Amendment. You know, I am audio and video recording, Mr. Pruitt.
I don't care. You have a permit to be here.
The First Amendment, actually.
You have a permit to be here.
No.
All right, you gotta leave.
Why is that?
Because you're going to jail if you don't.
I'm going to jail just for standing out here and
That's
holding
right.
the flag.
Demonstrating.
I'm a Marine Corps veteran. I'm a patriot. I'm a 3%er. I took an oath at the end of 2007 to uphold and defend our Constitution from all enemies, both foreign and domestic. My oath had no expiration date. Nowhere in the military oath is there an expiration date that says that this oath is only good until the time of your service ends.
You have to leave.
Okay, where does that super? Let me just. Can I just ask you? Can I ask you a question?
I'm gonna ask you one more time to leave. If not, I'm gonna get you to jail.
His uniform was a little bare that day. He had forgotten to put his badge back on before coming out. Took about 7 steps off, and I turned around to ask him what his badge number was. That infuriated him because it made him look horrible. Okay, I'll leave and take this straight to my attorney then. That's you can't threaten me with my First Amendment rights. Hey, I'm gonna tell you right now, Mr.
Count for you
Pruitt.
to leave. 1.
City is ass backwards. Ass backwards. Y'all see that? Hey, what's your badge number, by the way, Deputy Pruitt? No, I'm not. I'm leaving. I was asking you. I was arrested when I asked him what his badge number was. It infuriated him. He took me to the jail. I maybe was in the jail for about an hour before I posted bond. I grabbed my state flag. My car was parked right here on the square still. And I decided I was going to take a victory lap and walk from the sheriff's department with my state flag back to the square. And I did a victory lap around the square, holding my state flag, proudly holding my state flag. Because I knew what I did was not wrong. Even by the sheriff's department's own admission, and through multiple agencies, news agencies, I was arrested for holding the state flag on public property. Chain of events happens after that. I go to New Orleans, go stand up for the monuments under attack. I come back May 7th. May 8th, I have court the next day on a child custody hearing. I meet with my attorney for a lot of the day. I end up doing a countersuit against my ex, and I get the bright idea to go and serve her attorney. No matter what, no city, no county has the right to enact laws that directly go against the Constitution. But freedom, got somebody that illegitimate assumed the position as mayor of Oxford. Through the framing, silence of a Marine Corps veteran, patriotic American. You want to see the face of pure evil? Walk through those doors. You'll see somebody that clearly doesn't respect or follow guidelines laid out in our Constitution.
this entire time has pushed her evil, liberal, democratic playbook. The mercy of the freedom of somebody else. Trickle-down corruption has got to be stopped. And the only way that trickle-down corruption is going to stop is if you cut the head off the snake. You've heard of follow the money. Follow the web. You want to see what the deep state is? Go to writingwiththeoutlaw.com. There's so much proof on there, and I might have maybe half of the information uploaded to it that will be there. But this has become a problem that's larger than us, folks. Good officers are being put in harm's way because they're being made to choose between following the Constitution, upholding the Constitution, following the orders set by their supervisors, whoever's above them. And for any officer that's here, both the local police department, the Lafayette County Sheriff's Department, now is the time to actually do something about it, to push back, to actually do what you took an oath to do in upholding and defending the Constitution, protecting us from enemies, both foreign and domestic. And if you have a supervisor that's forcing your hand, that's doing something unconstitutional, violates the rights of others, now's your time to step out and to align yourself with me. So I'm telling you, I hold the keys to the castle. Yes.
The whole legal system has gone completely perverted. I don't know about other cases, I don't know about other people outside of what I'm particularly dealing in. But I've made numerous references to this over the past year and a half, honestly the last 4 years. It always used to be a presumption of innocence until proven guilty in a court of law, backed by the Constitution, and I guess Lafayette County, that doesn't apply. At least for me, it's a presumption of guilt until 100% of your innocence is proven. And with that comes taking away the right to even see my daughter over and over again. The evidence proves that this court in particular has been the biggest pivoting turning point for Lafayette County. And now I realize this is truly where my fight is. It's child exploitation. It's child trafficking through the Chancery Court of Lafayette County.
No. Why would you ask such a thing? See, that right there, that's a problem. When she asked, are they going to shoot you? You know, I've tried my best to get my kids to not fear the police.
We had a call, man. Oh.
What's this one about?
So what?
And what's this one about?
Did you fly a drone into the building or something?
By accident, I hit the right joystick. I went forward instead of up. I was trying to actually slowly move in and get some different vantage points of both Lafayette County from the air as well as the flag. And I am a member of the press. Accidents do happen. There was no damage except for my propellers, and that was what I was trying to replace. So, yeah, actually working on it right now. So I got the, do what? Because of the flag. The beautiful vantage point right there from the air. I mean, I think it's I haven't seen any videos that have utilized aerial photography coming into Lafayette County Justice Court. And I can't think of a better purpose, being that I'm rolling a documentary on this court and the Chancery Court and the Circuit Court, as you know. This is. I understand that, but I had a feeling this is going to be made into an overreaction, just given the whole circumstances of everything. So,
I'm on. They got a $20,000 bond set. Both of them is $20,000.
Maybe not way up.
when I was, my parents got divorced. I moved out here with my dad, and we lived off of Pumping Station Road, 84 County Road. You and I, actually, you're probably younger than me. 32? Yeah, I'm 34.
That's a long time ago.
I have to think about that every time, because it's like, damn, it's getting on up there. Seems like last I knew I was 33, and then,
The worst part about everything is...
No, because honestly, I was... But, all right, what crime am I being accused of committing?
You got on fresh credentials, you got to have a commercial license filed when you identify yourself to where you're licensed.
Really?
Really.
That's also a weighted drone.
I'm not arguing with you. Where'd you license? Pull it up on the email.
I actually don't even feel comfortable reaching in here to grab my other phone. You want to write me a ticket for not having a commercial license? You're more than welcome to do that. I can't find my phone right now. This is my new phone. My iPhone 8 Plus is what's signed into the Google, the Gmail. This is brand new. This is actually my wife's. There it is. Oh. There it is. There you go. Do you know how many phones I've broken? From leaving? Oh, yeah. Oh, yeah. So, I would read over them. Oh, yes. I said I would read over the press credentials, what it says, the language that is in there. It doesn't. Down in the good old boy system of law.
Back up for the day and go and get your license straight. Be in touch with the U.S. Attorney's Office.
The U.S. Attorney's Office. Yes, they do. It's in every court. God knows that I'm in enough of those right now. Right? I've actually welcomed the U.S. Attorney's Office to join in.
117 on 401.
Yeah.
Correct address.
Yeah.
It's not in Calhoun.
No, I mean I've got multiple mailing addresses. That's one of them.
Where you live, where you lay your head.
Yeah. P.O. Box 1360.
That ain't where you don't lay your head at the P.O. Box. You lay your head at a house. So if you live in Calhoun County, give me your address where you live.
I mean, that's been the address that I've been given.
Where do you live?
Wade the Fifth.
So it's not the 117.
Because my ex, Liz Crowder, has been trying to get that information. That's the whole reason the Justice Court stuff and the Chancery Court stuff exists. Y'all know that very well. And me giving up my address means her getting my address, which means that I then get attacked by false allegations. She's already accused me of rape. I have very good legitimate reason to not disclose my activity.
I won't give Liz Crowder any information.
So if there's a law that says that it can't be a mailing address and actually has to be a physical address, and I have to disclose that, then I'd like to see the supportive language.
That's true, brother. That's fine.
But right now, I'm outside of Terry stop time.
You roll your
time stipulations.
You only leave.
Okay.
All right, man.
All right, guys. Come here, Alan. Here, sit back. Yep.
I got lost the tape.
Please pray come see.
Okay, I said I had about 5 minutes, and I mean it, to destroy any argument by the Mississippi State Attorney General's office. That's what I'm going to do. What does Article 3 of the Bill of Rights mean? I think I need to give them some schooling on that. I think the state of Mississippi needs some schooling on federal law. I think it's time to deal a crushing, one-and-done blow to that damned good old boy system of law. Article 3 of the Bill of Rights, Section 1. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. The constitutional requisites under Article 3 existence of standing. The plaintiff must personally have. It's 3 different factors here. Number 1, suffered some actual or threatened injury. 2, that injury can fairly be traced to the challenged action of the defendant. And 3, that the injury is likely to be redressed by a favorable decision. 1, 2, 3, hit the nail on the head. What's in justice court right now 100% meets the criteria for removal from justice court to be tried in federal court in the district court for the Northern District of Mississippi. Since day one, I've stayed consistent on deprivation of due process rights and deprivation of equal protection of the laws. I haven't wavered. Call me crazy, I've talked about the same thing. And it's funny, kind of like the story of the tortoise and the hare. My actions may have seemed very much like the hare at times, but really when you get to peeling back the onion, looking underneath the hood, a lot of people are going to find out that they're really quite turtlesque. Prosecutorial misconduct. There's a lot of that going on right now in justice court. This is what's going to hammer them over the head hard. When a conviction is obtained by the presentation of testimony known to the prosecuting authorities to have been perjured, due process is violated. The clause cannot be deemed to be satisfied by mere notice and hearing if a state has contrived a conviction through the pretense of a trial which in truth is but used as a means of depriving a defendant of liberty through a deliberate deception of the court and jury by the presentation of testimony known to be perjured. Such a contrivance is as inconsistent with the rudimentary demands of justice as is the obtaining of a like result by intimidation. What do you know? 9 charges. You have the recent stuff with Scott Mills, Joey East. Doesn't take a rocket scientist to know that there's a huge abuse of power, a long-time corrupt good old boy system which is trying to use intimidation like they did back in 2017 to cover up wrongdoing of Timmy Pruitt and to hide it with more wrongs and then to try to seal everything up with the covenant to not sue and banishment. 1154 Mooney v. Holohan, 294 U.S. 103. That requirement in safeguarding the liberty of the citizen against deprivation through the action of the state embodies the fundamental conceptions of justice which lie at the base of our civil and political institutions. Hebert v. Louisiana. Is a requirement that cannot be deemed to be satisfied by mere notice and hearing if a state has contrived a conviction through the pretense of a trial, which in truth is but used as a means of depriving a defendant of liberty through a deliberate deception of court and or jury by the presentation of testimony known to be perjured. Such contrivance by state to procure the conviction and imprisonment of a defendant is an inconsistent with the rudimentary demands of justice, as is the obtaining of a like result by intimidation. Here's the key one. In the action of prosecuting officers on behalf of the state, like that of the administrative officers in the execution of its laws, meaning the Sheriff's Department, the Attorney General's office, those that set laws, that enforce laws, may constitute state action within the purview of the 14th Amendment. That amendment governs any action of a state, whether through its legislature, through its courts, or through its executive or administrative officers. Carter v. Texas, Rogers v. Alabama, Chicago, Burlington, and Quincy v. Chicago. The principle enunciated has required state officials to controvert allegations that knowingly false testimony had been used to convict, and has upset convictions found to have been so procured. Extending the principle, the court in Miller v. Pate overturned a conviction obtained after the prosecution had represented to the jury that a pair of men's shorts found near the scene of a sex attack belonged to the defendant and that they were stained with blood. The defendant showed in a habeas corpus proceeding that no evidence connected him with the shorts, and furthermore, that the shorts were not, in fact, bloodstained. Let's draw the similarity here. There was not, in fact, an AR-15 back in 2017, and that the prosecution had known these facts all along. Nafu v. Illinois, Alcorta v. Texas. In the former case, the principal prosecution witness was defendant's accomplice, and he testified that he had received no promise of consideration in return for his testimony. In fact, the prosecutor had promised him consideration, but did nothing to correct the false testimony. See Giglio v. United States. In the latter case involving a husband's killing of his wife because of her infidelity, a prosecution witness testified at the habeas corpus hearing that he told the prosecutor that he had been intimate with the woman, but that the prosecutor had told him to volunteer nothing of it, so that at trial he had testified his relationship with the woman was wholly casual. In both cases, the court deemed it irrelevant that the false testimony had gone only to the credibility of the witness rather than to the defendant's guilt. What if the prosecution should become aware of the perjury of a prosecution witness following the trial? More than 30 years ago, this court held that the 14th Amendment cannot tolerate a state criminal conviction obtained by the knowing use of false evidence. Mooney v. Holohan. There's been no deviation from that established principle. Napu v. People of the State of Illinois. Powell v. State of Kansas. Alcorta v. State of Texas. There can be no retreat from that principle here. This line of reasoning has even resulted in the disclosure to the defense of information not relied upon by the prosecution during trial. In Brady v. Maryland, the court held that the suppression by the prosecution of evidence favorable to the accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. In that case, the prosecution had suppressed an extrajudicial confession of defendant's accomplice that he had actually committed the murder. The heart of the holding in Brady is the prosecution's suppression of evidence in the face of a defense production request where the evidence is favorable to the accused and is material either to guilt or to punishment. I've asked for things over and over and over again. They've gone ignored, but they expect me to go to trial. Important then are A, suppression by the prosecution after request by the defense. B, the evidence's favorable character for the defense. And C, the materiality of the evidence. In United States v. Augers, the court summarized and somewhat expanded the prosecutor's obligation to disclose to the defense exculpatory evidence in his possession, even in the absence of a request or upon general request by defendant. First, as noted, if the prosecutor knew or should have known that testimony given to the trial was perjured, the conviction must be set aside if there's any reasonable likelihood that the false testimony could have affected the judgment of the jury. Second, as established in Brady, if the defense specifically requested certain evidence and the prosecutor withheld it, the conviction must be set aside if the suppressed evidence might have affected the outcome of the trial. Third, the new law created in Augers. If the defense did not make a request at all, or simply asked for all Brady material, or for anything exculpatory, a duty resides in the prosecution to reveal to the defense obvious exculpatory evidence. Under this third prong, if the prosecutor did not reveal the relevant information, reversal of a conviction may be required, but only if the undisclosed evidence creates a reasonable doubt as to the defendant's guilt. I mean, just bam, 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 bam. Corrective process, appeals, and other remedies. A state is not free, however, to have no corrective process in which defendants may pursue remedy for federal constitutional violations. In Frank v. Mangum, the court asserted that a conviction obtained in a mob-dominated trial was contrary to due process. If the state supplying no corrective process carries into execution a judgment based upon a verdict thus produced by mob domination. This has been mob domination in Lafayette County since day one. It's still there. It's still going on. I can't get an attorney. It's because it's a mob of influence. The state deprives the accused of his life or liberty without due process of law. Some form of corrective process when the convicted defendant alleges a federal constitutional violation. I've alleged numerous. Contravenes the 14th Amendment, so I have standing, and the court has held that to burden this process, such as by limiting the right to petition for habeas corpus, is to deny the convicted defendant his constitutional rights. Habeas corpus went ignored. The mode by which the federal constitutional rights are to be vindicated after conviction is for the government concerned to determine. Wide discretion must be left to the states for the manner of adjudicating a claim that a conviction is unconstitutional. States are free to devise their own systems of review in criminal causes. A state may decide whether to have direct appeals in such cases, and if so, under what circumstances. In respecting the duty laid upon them, states have a wide choice of remedies. A state may provide that the protection of the rights granted under the federal Constitution be sought through writ of habeas corpus or coram nobis. May use each of these ancient writs in its common law scope, or it may put them to new uses, or it may afford remedy by a simple motion brought either in the court of original conviction or at the place of detention, habeas corpus. So long as the rights under the United States Constitution may be pursued, it is for a state and not this court to define the mode by which they may be vindicated. So not only are they refusing me vindication where they have to, but they're persecuting me on 9 additional charges, expecting me to go to trial in lieu of a demand for a jury trial. You have the judge that was originally linked in with everything that's picking the damn Justice Court judge. You have discovery being withheld, refused, key discovery necessary for trial. There are so many due process rights. Lafayette County has gone on tilt. They said, we've denied most of them to him, we've gone this far, and damn it, we're going to deprive every single bit of his due process rights here going forward. No right to trial by jury, no right to evidence, didn't give him a preliminary hearing, false imprisonment, multiple violations of the RICO Act, child exploitation, human trafficking, extortion, and so many damn counts of conspiracy. Joey East wants to always joke, always laugh and say that it's another Matt Reardon conspiracy. I just let him laugh. He clearly doesn't know the legal definition of what conspiracy is, which is basically a plot. Conspiracy is a conjured up plan, a plot between 2 or more people. And when one of those 2 people just happens to be an officer working under color of law, it aggravates it to a federal level. I have 100% standing. Should the state continue going down the path that it's going down, refusing to afford some type of redress to the situation, then the federal courts are going to jump in.
I have no problem involving them. It's where this belongs anyways.
Plenty of case law backing it up. And this is precedents that they've said time and time again. Not even the first case can be gone against. It's that crucial, that important. See you at the finish line.
It's an ongoing building block into 3 different books that I'm working on. One of them is about writing with the outlaw, my adventures in being politically charged, politically framed, having all the evidence of government involvement, deep state involvement, a bunch of corrupt attorneys, even the courts. The second one's going to be about all the shenanigans with Phyllis Liz Crowder, my ex, mother of my child. The false, just the insanity that encompasses that. All the frivolous, false claims and my stand against it. Even when it came to having to represent myself because I couldn't find an attorney to help me. Meanwhile, she's got attorneys bending over backwards to help defend her lies. I'm pretty sure we're on the third. And that'll be the more familial aspect about how my family turned their back on me. Especially at a time that I needed them the most. Especially in seeing the undeniable proof. Seeing me steadily drowning more and more, sinking in quicksand. And yet, it's one thing not to contribute or help out. It's another thing to actually completely turn your back on somebody that is struggling with the particular things that I've run into with all the adversity, the biggest challenges of my life, and to be one man going up against a ridiculously corrupt system that continues to break laws, that continues to carry their witch hunt on. I need a prayer.
In the Circuit Court of Lafayette County, Mississippi, Matthew Reardon, plaintiff, versus Judge John Kelly Luther and Judge Carolyn Bell, defendant. This is the petition for writ of mandamus. Plaintiff Matthew Reardon hereby petitions for a writ of mandamus and seeks an order from the higher court granting this petition for a writ of mandamus and directing the circuit court judge to grant relief sought on his motion filed December 23, 2020, in conjunction with criminal cause LK17-295, or in the alternative to promptly recuse himself as trial judge. Plaintiff in this cause has faced some of the most extreme prejudicial treatment and handling by the state of Mississippi, whom plaintiff directly asserts has continued to persecute the plaintiff on a plethora of criminal charges in order to attempt to stack the deck and demonize him in the eyes of the public, along with various courts. Plaintiff stands exhausted and mentally fatigued from having to prepare defense to an ever-growing list of court hearings, all of which directly stem from the original ruling made July 7, 2017 in criminal cause LK17-295, in which Judge John Kelly Luther presided and ruled in what plaintiff asserts to be the most tainted, corrupt, highly prejudicial, and unlawful legal charade, which is a complete abuse of power and proceeding, aka witch hunt, in at least the last decade, if not the past century. Plaintiff has continued and will continue asserting his claim that the trial court knowingly chose to toss its own procedures, rules, laws, ethics, and moral turpitude to the wayside, and in the act of doing so blatantly disregarded mandated procedures laid out in the Mississippi Rules of Criminal Procedure, which was detailed out in the plaintiff's motion for relief from judgment under MRCP Rule 60 submitted to the trial court on December 23, 2020. Plaintiff acknowledges that he has a pending appeal before the Court of Appeals, which was recently docketed on 3/10/2021. However, MRCP Rule 60 states, to wit, leave to make the motion need not be attained from the appellate court unless the record has been transmitted to the appellate court and the action remains pending therein. Plaintiff is beyond belief that the defendant circuit court judge has not only been allowed to continue presiding over this case, but other cases amongst the serious claims made, which he adamantly has refused the plaintiff an opportunity for an evidentiary hearing, which the record itself and the facts of the criminal cause LK17-295 should not even require, based upon interpretation of the Mississippi Rules of Criminal Procedure, the Mississippi Rules of Civil Procedure, and the Code of Judicial Performance. It is the impression of the plaintiff that there is only one acceptable remedy to this matter: to vacate the plea and judgment entirely, based solely in principle on the state of Mississippi and both defendant judges denying the plaintiff on this writ certain key due process unalienable rights, and in turn denying him all opportunities for a fair trial to take place. As stated all along, and particularly in the motion submitted on December 23, 2020, the meritorious reasons
that have been claimed and listed should in fact render the plea and judgment to be null and void, even unlawful and unconstitutional, based upon established state and federal law and long-standing court precedents based upon the seriousness of everything. These incurable errors have been previously detailed out, but include, among others, fraud, misrepresentation, misconduct of an adverse party, newly discovered evidence, the fact that petitioner's bond was set unconstitutionally high in a punitive way, 3 times higher than the maximum stated on the guidelines for bail, readopted less than a year prior, a habeas corpus petition approved by Judge Howarth, which was never acted upon, no preliminary hearing ever being set, and all bond reduction requests completely ignored. At this point, plaintiff would naturally have to question the misconduct at hand, further characterizing it as intentional criminal conduct, which would give off all feelings and impressions of a deeper level of involvement from the grave misconduct of the 2 judicial officials listed in this petition, along with Municipal Court Judge Leslie Shoemake, which is currently pending before the U.S. District Court of the Northern District. Plaintiff formally requests for an impartial formal investigation to be ordered into the claims plaintiff has made and produced evidence of, and for the plea and judgment on LK 17-295 to be rendered invalid, or in the alternative, for a hearing on the evidence and facts to be ordered. Should a hearing on the evidence and facts be ordered, plaintiff immediately moves for recusal of Circuit Court Judge John Kelly Luther from the matter due to the grievances listed, along with the inability to preside following submission of a writ of mandamus, which requires further that the Circuit Court Judge recuse himself from all matters involving the plaintiff. Plaintiff requests for the Justice Court Judge Carolyn Bell to be remanded for her actions in setting an unconstitutional bond 3 times higher than the maximum guidelines called for in LK 17-295, and further refusing to allow the defendant in that cause to speak in order to show unquestionable proof of his innocence to the matter, nor allowing the defendant in the cause to proceed with setting a preliminary hearing. Filed motion for relief from judgment under MRCP Rule 60 is filed and attached hereto as Exhibit A. Respectfully submitted. The first day of April 2021. This is not an April Fool's Day joke. Matt Reardon, the Oxford Outlaw.
The whole legal system has gone completely perverted. I don't know about other cases, I don't know about other people outside of what I'm particularly dealing in. But I've made numerous references to this over the past year and a half. Honestly, the last 4 years. It always used to be presumption of innocence until proven guilty in a court of law, backed by the Constitution. And I guess the Chancery Court of Lafayette County, Judge Robert Whitwell, that doesn't apply to. At least for me, it's a presumption of guilt until 100% of your innocence is proven. And with that comes taking away the right to even see my daughter over and over again. The evidence proves that this court in particular has been the biggest pivoting turning point for Lafayette County. And now I realize this is truly where my fight is. It's child exploitation. It's child trafficking through the Chancery Court of Lafayette County.
Petition for permission to interlocutory appeal to the Mississippi Supreme Court. Pursuant to Rule 5 of the Mississippi Rules of Appellate Procedure, Matthew Reardon, the respondent and defendant in the above captioned cause, files his petition for permission to interlocutory appeal to the Mississippi Supreme Court. Movant states that this petition is filed in good timing and most certainly with good merit, based on grounds for which relief through interlocutory appeal may be sought. Movant would affirm that he has continued to sustain repetitive injuries at the baseless, frivolous, and vindictive hands of the petitioner, the petitioner's legal counsel, along with the state of Mississippi. Movant states that each motion brought before this court has been prejudicially ignored, with preferential treatment shown to the petitioner in this cause the entire time, despite the fact that petitioner has had a history of filing false reports, and this very cause will show the furtherance of petitioner's continued behavior, which is not only morally incomprehensible, but in fact rises to the level of criminal conduct by flagrant and uncaring violations of Mississippi Code 97-7-10, fraudulent statements and representations, along with Mississippi Code 97-1-1, conspiracy, which the state of Mississippi has refused to acknowledge, condemn, and deter, despite petitioner meeting literally every criteria of the statute needed for indictment by a grand jury. Yet through what would easily appear to be culpable negligence at the hands of state actors acting under color of law, she has continued to get away with the intentional infliction of injuries upon the respondent/movant, and this court is further feeding into it by immorally changing a standing order when absolutely no evidence was produced and court proceedings were delayed. Movant further demonstrates the preferential treatment shown through his filing of a motion to dismiss, or in the alternative to transfer venue, filed 11/16/2020, on the basis that venue, while jurisdictionally is proper, is in fact improper in the Chancery Court of Lafayette County, Mississippi, due to reasons of constitutional law, equity sought and counterclaimed by the respondent due to the injuries sustained, zero evidence produced up front as a way of justifying 9 months contempt in violating a visitation order, and a jury demand by the respondent and movant for these reasons stated. This motion is attached to this filing as Exhibit A. It would most certainly appear that any response or forward motion brought by movant is destined to fall on blind eyes and deaf ears, despite all evidence almost certainly warranting the dismissal of petitioner's cause. Petitioner, along with this court, moved on their own to enter an order of supervised visitation and appointment of guardian ad litem, which was drafted by the petitioner's attorney, accepted, signed by the judge, and filed by this court unsigned by the movant, despite his motion to dismiss or transfer being open, unanswered, and ignored by this court. Order filed a judge without movant's signature is attached as Exhibit B. Despite serious issues of law, ethics, and criminal wrongdoing raised and alleged, none of this mattered. It is entirely the opinion of the movant that influence, along with ongoing pending litigation over extreme civil rights violations committed through officials of Lafayette County, have in turn created what movant cites as a constitutional crisis by way of trying to fix a desirable outcome through the initiation of frivolous and undeserving proceedings, done with ill intention, and further using the pressure of keeping movant's minor child from him to make him cave on a matter. This was precisely the case in May of 2017, and movant has been consistent in stating the same claims about how his minor child was used as a manipulation tool of the courts by the minor child's mother for her own personal gain, whom by ways of collusion and criminal conspiracy plotted in many ways were successful in eliminating or reducing the legal liability stemming from the actions of certain individuals and officials in Lafayette County, Mississippi, whom will be named in a separate court filing. The fact that this court allows her to carry on despite her claims raised as complete lies, and in light of her having a history of pathological lying through the false reporting of crimes, is an absolute shame, and one that should question the validity of other rulings, or if this was simply isolated. While movant has continued to gain more legal knowledge, especially in the composing of briefs, motions, petitions, and responses, true justice is nowhere in sight. Movant asserts and affirms through multiple recent examples, including this cause, there's been a clearly shown lack of adherence and care to the equal protections under the laws which are afforded to all citizens under the 14th Amendment to the United States Constitution, a system designed to provide due process, and one that should stay non-biased would appear to have drifted away from acceptable norms that would garner and keep the trust of citizens. It is now clouded with uncertainty. The first question Movant would pose is what good are laws and why were laws instituted if they could be so bludgeoned and blatantly abused? Even when such abuse is brought to the attention of those tasked with upholding and enforcing the laws, does the state of Mississippi actually condone this type of behavior? And even more so, do they condone the culpably negligent actors, whom are fully aware of it, and allow the continuation of such, despite the damage continuously inflicted by the victim, who has exhausted all remedies and is seeking immediate relief from the government tasked with protecting its citizens by way of providing equal protections under the laws? Our country is operated under the policy in name of innocent until proven guilty in a court of law. I say in name because it's something that exists clearly just to sound good and give off false hope to anyone suffering at the hands of a completely flawed criminal justice system, when in fact all too often the accused is looked at and treated as guilty until they prove their innocence. That fact is made blatantly clear in this cause, and it couldn't be any clearer. After 2 scheduled hearings, the petitioner has not produced one single strand of evidence which would even suggest she has a valid, non-frivolous claim. And in fact, every motion and response filed by respondent Movant has stated in fact very serious claims of petitioner having a history of making false reports, and that Movant was advised multiple times that the petitioner was lying through her teeth, and that they would never assert any of the such, which petitioner has asserted now on 3 separately filed documents filed with this court under signed and sworn affidavit. Has this court even one time considered an obvious, most certain guarantee that law enforcement would have been involved had any of petitioner's claims been true? There would have been some report by the proper agency and authorities brought before this court and shown up front as grounds to keep a father from normal scheduled visitation with his child for 10 months now. Even more concerning is the fact that Movant was barred from even seeing his child by the petitioner in this cause, despite her being in receipt of $600 in child support paid every month.
Here on the petition for modification, citation for contempt, another relief that I filed on behalf of my client, Liz Crowder. Mr. Reardon has been properly served and we're properly before the court on that matter.
You same thing?
Yes, Your Honor. I did not get her served prior to the 7 days. However, I did serve them with a answer and a counterclaim, which honestly incorporates my petition into it.
Well, unfortunately, Rule 81D2, anybody that's served with a petition for citation for contempt is allowed 7 days notice by personal service, not by mail or by some other means delivered to this defendant. That is not sufficient service. So you do not have process on this crowd for your petition.
Yes, Your Honor. But I was saying my petition's still open. I haven't gotten her properly served on my petition yet. I did file an answer to their petition with a counterclaim attached to the answer.
Counterclaim for contempt.
It's a counterclaim on the whole ordeal, not just contempt.
Still got that 7-day process. So you're not prepared to go forward on your counterclaim.
I'm prepared to go forward on the merits of this case today, Your Honor.
The merits of this case is going to be Ms. Rivers, Ms. Crowder's petition.
That's perfectly fine.
Proceed. Now, what the court would suggest is that if you want to continue your case so you have time to serve her, we can continue Ms. Crowder's case and put it all on one day.
Your Honor.
Proceed on her count against you today, then we'll just proceed on her count.
I would like to proceed on her count against me today because I've once again, my daughter's been ripped away since the end of May. this has got to be stopped. I mean, she cannot have the right to overrule your order and take it on herself. It needs, this is something serious and needs to be addressed.
What's your position on that?
Your Honor, as part of the petition for modification, we've requested a nail bed testing for drugs and alcohol for Mr. Reardon. As the minor child is involved and Mr. Reardon was arrested in Bruce for possession of paraphernalia, we would request prior to our going forward on this matter that he be tested and it be court ordered and, supplied to the court.
Your Honor, there are no open charges in Bruce. There was simply a family disturbance that everything was retired. There's nothing open, and all of that honestly stemmed from the affiant here withholding visitation of the child on Father's Day weekend. But nothing's open in Bruce. Nothing's currently open. What's that, Your Honor? No, Your Honor. There's nothing open.
Your Honor, I don't believe that was an answer to your question. The question was he charged? The answer is yes, he was charged. I have a copy of the abstract, and Mr. Reardon is correct. It has been retired to the file, pending the fact that he doesn't get into any more trouble, whether domestic or otherwise, in Bruce. And Mr. Reardon has been arrested for DUI this year. Your Honor, we're just requesting for the safety and in the best interest of the minor child that he be tested, and then we can go forward. I think we all know that those test results could be back in 7 to 10 days, and we can go forward at that time once we have those results. But on the last time that we were in court, and Lori Solinger was appointed the guardian ad litem, she requested of Mr. Reardon to have drug testing done repeatedly, and he refused to have it done. He refused to let her come out to his home. Your Honor, that doesn't do anything but confirm the suspicions that he's used.
Objection. Your Honor, this is nothing more than just speculation. This is them trying to intrude into other currently open court matters. And to be honest with you, Your Honor, I have a Fourth and a Fifth Amendment right against self-incrimination. They're trying to intrude where they have no business being. Nothing was involved with the kid.
Well, what about the fact that you requested to do the drug test and didn't do it?
Your Honor, once again, there was an open matter that's currently in justice court. I'm of the standing that I have a Fifth Amendment right against self-incrimination when there's currently open legal matters. They are intruding into a currently open court.
I'm talking about what's going on in this court.
Yes, Your Honor, but there's been nothing that's gone on involving the child. The child has been ripped away from me the majority of the time.
You're talking about with the child because you've been charged with drug paraphernalia.
You're
retired to the file pending your good behavior.
Yes, Your Honor, but my car has also been open. The window's been knocked out. There's no security as far as locking my vehicle up. So the paraphernalia charge that came from that arrest, for one, there was never consent to even do a search, and for two, the vehicle was already compromised on security. Miss Crowder has falsely accused me of rape. She's falsely accused me of molestation. Who's to say that Miss Crowder didn't plant the paraphernalia?
You got any proof of that?
That's the problem, Your Honor. I have no security to lock my car. But twice now, she's falsely accused. This last time, the last time that we were in court, she had asserted for 13 months the Department of Child Services had advised her to keep the child from me. That was proven based on the DHS records.
We entered an order on that last hearing, settling that matter.
But she,
going back behind that order.
Your Honor, when she went in contempt of the order, though, she nullified it. effectively, she never abided by any terms of the order.
Well, you get process on it, we get a hearing on that, we'll discuss it. Till you do, we're not going to discuss it. Based on the history of this case, I'm going to require you to have a nail-bed drug test, and we'll reset this case. You get process on her, we'll reset it.
I'm going to appeal that, Your Honor. I'm going to notice the court of my intention to appeal.
You got a right to appeal. You figured that out. I'm going to order, and I hope you abide by my order. Doesn't mean my order, I'll order that he have to take a drug test immediately within the next few days.
And Your Honor, pending the results of that nail bed test, is visitation suspended?
I have not had it since May, Your Honor. She kept the child from me on Father's Day weekend, which is... Don't shake your head.
Well, I'll tell you what you do, Mr. Reardon. You get the nail bed test, you pass it, and your visitation will be reinstated.
I never deserved to have it taken away in the first place. This is complete manipulation.
At least 6 or 7 days.
How does this court even justify allowing her to go in contempt of a judge's order to begin with? What gives her the right to overrule your signed order, Your Honor?
You didn't follow the rules. You don't have...
How? She didn't follow the rules in the first place.
You'll have your day in court, Mr. Reardon.
This is going on for 4 years. Enough is enough.
You let him do the same thing last time you settled the case. I ain't even had a hearing on this. So we're going to have a hearing on it. But you get processed. And you'll be treated like anybody else. Just like everybody else that comes through this court. You'll get justice just like anybody else. So you obey my order or be in violation of it, whatever.
Okay. Try something new. I'm down in downtown Water Valley. And this is where I first came when I got out in July of 2017. I gotta say, I miss this place a lot. Something about a small town. It's a rarity for me to ask anyone for anything. But on behalf of myself, my wife, and my children, I'm going to ask anyone willing and able for relief. Those that know me know that I've always been one not to ask for assistance. The times I've had to, I've honestly been procrastinating to the very last second because the fact of the matter is, I just don't like conveying the fact that I need help. So it shouldn't be much of a shocker that this is no different. In just the past 4 years alone, I've been very outspoken in regards to our rights and liberties bestowed upon us. Make no mistake about it, contrary to what our quickly evolving government would have you believe, there's never been any such interpretation of our laws, both state and federal, that would characterize any of our key rights as being gifted rights granted to us by our government. They are in fact bestowed upon us at birth. Rights that we were born into. Rights granted to us by our Creator, whom to me is God. It was both the lifelong oath that I swore back in 2007 and my knowledge and training acquired that makes it my obligation to ensure that tyranny never prevails on American soil. In doing so, I've faced political persecution and even political false imprisonment. I honestly feel as if I sold my soul to the devil himself on July 6, 2017, when I pled out to the witch hunt charge placed against me as a barter in exchange for my freedom. They call it a voluntary plea, but in reality, it was everything but voluntary. all due process rights of the accused were intentionally withheld and ignored, beginning with it taking nearly twice the amount of time required by law to bring me before a judge for an initial hearing after arrest on their sham charge so that bond could be set. This immediately followed up by Justice Court Judge Carolyn Bell setting my bond 3 times higher than the maximum stated bond that a crime which would have seen 10 years in prison would have maxed out at, despite me asserting that I had exculpatory evidence of my innocence through a bill of sale. Not only was I innocent of this charge, but in fact no crime was ever committed. There was never truly a victim, despite the fraudulent statements made. The third strike would have been the refusal to set a preliminary hearing in order for my innocence to be proven up front. Not to mention, the judge never even advised me of my right to a preliminary hearing. She only wanted to advise me of my right to remain silent. Finally, an ongoing chancery court battle that had my innocent daughter tied up in it. I had to get out. I had to prevent further damage from happening, which was all but certainly going to affect her. All of it an aggressive plan to keep me suppressed through acts of treason, further intensified through it being politically motivated and it helping an election, the new mayor's ascent to office, and the fly-by-night changing of laws without so much as the consent, much less the knowledge of the government. I've had to fight my way out of every single situation that's arisen. I've paid every bond that's come about from being directly retaliated against solely for my expectation of accountability, justice, fairness, and equality. I've had employment opportunities destroyed based upon my name and continued conspired upon lies stemming from Lafayette County. The individuals that played the original part in everything, and individuals that are friends with those particular individuals. My wife has faced the same, all due to the man she happens to share a last name with. As if that's not bad enough, when factored together, my 7-year-old daughter, Lydia, continues to fall victim to child exploitation and human trafficking through the combined help of her mother, her mother's attorneys, and the Chancery Court of Lafayette County, in which the assigned judge has allowed a continuous knuckleball to be thrown to the middle in a never-ending plot to rid my child from all. I mean, some of the most ridiculous lies ever imagined vomited onto petitions and affidavits, regardless of every lie under affidavit being disproven and dispelled. The judge actually allowing her to get away with it time and time again, prejudicially adjudicating me guilty until or unless I prove 100% of my innocence. And even then, nothing happens to the other side. Their ridiculous stunt pulled, and all the time lost with my daughter. So I'm done playing those games and having to prove my innocence. The system is clearly broken and in bad need of reform. All of everything that has happened has been done with the illicit intent as an intentional ploy to manipulate legal proceedings and abscond with their legal liability, created through the commission of their own crimes. It certainly harmed me, my wife, and our kids in many more ways than one. One of the most significant is the intentional targeting of ways for me to financially support my family, obtain an attorney, and the steady ongoing effort of trying to derail me from any one of multiple ongoing legal proceedings at any given time, if not all. While it's been the biggest source of knowledge and a humbling journey so far, being that I'm still standing on my 2 feet despite all that's been hurled at me, it has certainly affected me in ways that have had me withdrawing from my family roles due to stress and time constraints. It's time to hire an out-of-state attorney to handle things from here on out. I can't keep up with everything on my own and perform all the necessary tasks a licensed attorney can do. So while I hate asking for me, I'm going to ask for them in order for me to provide for them, to fight back all the injustices we have faced, keeping the fight fueled in the courts, and seeking full restoration of my life through complete vindication. At this stage of the game, I feel like it's a necessity for me to find financial backing through the compassion of others, whom are willing and able to provide assistance. After all, I haven't seen the first politician that's prevailed when challenged, and not done so by the help of fundraising, donations, and support behind them. The same goes for just about every cause and type of activism work. Most certainly, what I'm facing here. If we bend even the slightest and allow even one of our rights to get pushed over and disregarded, all will quickly become pushed over and disregarded. It's the way precedence works, and precedence is what has run the court system all along.